Good morning, everybody. Thank you for joining us this morning. My name is Caitlin Annis, and I'm one of the directors at Merrick HR. Welcome to our first HR Club of 2026, where we will be looking at managing grievances. It's one of our back to basics sessions. Before I introduce the speakers, just some housekeeping for the session. If you do have any technical issues today, please check the Zoom settings in your Zoom banner. Leave a message in the chat box below, or alternatively try disconnecting and reconnecting to the session, which will hopefully sort out problems. If you do have any questions throughout the session, we're very happy to answer them as we go along, or we have got a Q&A session at the end. Please pop them in the Q&A box and not the chat box. We will aim to answer as many questions as we can, time permitting. The webinar is being recorded, and we will aim to send you a copy of the slides along with the recording in the next few days. Just a date for your diary. Our next HR Club is on the 14th of May, and that one is focused on the effective use of probation periods, something which is going to become increasingly important with the changes coming in under the Employment Rights Act. But today's session focuses on the management of grievances. We'll give some practical insights and tips on best practice. Our speakers today are Simon Martin and Claire Parr, who are both HR consultants in the Narrowkey team. I hope you enjoy the session, and I'm now going to hand over to Simon.
Caitlin, hi everyone. So Caitlin, can you just move on to the next slide, please? So what we're going to look at today between me and Claire is we're going to look at what is a grievance, and this is a surprisingly involved answer. And then we're going to look at how to run a grievance meeting. And that's really when I talk about grievance meeting, I'm really talking about the whole process, including possible investigations and mediations. Then Claire's going to look at how to deal with counter grievances that they often crop up, grievances that crop up during disciplinary processes, and decision making, how you should go about that. And then I'm going to come back in and talk about do's and don'ts. As Caitlin has mentioned, we are happy to take questions throughout the session. If you just pop them in the Q&A box, Caitlin will keep an eye on that. And also at the end, there's our final slide is just saying questions. So if there's anything that you haven't managed to ask then during the session, then please ask it then. So let's move on to the first question then of what's a grievance. So next slide, please, Caitlin. Thanks. So I'm going to ask you to vote on this shortly. So is it someone just passing on a complaint made by a colleague? Is it someone just verbally complaining about their manager? Is it a written complaint about being undermined? Or is it someone presenting their evidence in a disciplinary investigation? So which one of those do you think is a grievance? So if we can launch the poll now, please. So you just click on what you think is the right answer. Jama, can you? Right, there we go. There's the poll. Right, we seem to have slowed down, and I think we've got a winner. I think we've got a winner. So we can. So we've got 100% on that. So let's stop sharing that. So right. So can we share the results now, please? So right, so we've got right. So we've got the question of someone passing on a complaint made by a colleague. I think it's worth going back to the definition of what the ACAS code say is a grievance. So that is the ACAS defines grievances as concerns, problems, or complaints that employees raise with their employers. It goes on to say in the same code, the grievance should be in writing and set out the nature of the grievance. So that's the very specific rule set out by ACAS. So the the question, though, is, well, what about the rest of it? Yes, the third one is, sorry, can we just end that poll now? Right. So the question is, well, yes, the third one, the written complaint made by a colleague that said their manager is undermining him, that is a classic grievance. But what about the second one? What about someone complaining verbally about their manager? What about if that person is Isabel, who's, a new young member of staff, and she's saying, actually, the reason I'm not coming to my I was hesitant about coming tonight is I didn't want to bump into the manager. He's been a bit handsy with me. Now, is that something, because it's not written down, is that something that you would say, well, isn't a grievance, so we don't have to do anything about it? So I think that there's a risk that you can become too blinkered by saying, well, because it's not in this set format, we're not going to do anything about it. And equally, someone's evidence in a disciplinary investigation, it may be that some of that evidence is also something worthy of investigation in its own right. And when we're doing our investigations, these things often crop up, and we will make recommendations about that, saying, "Look, someone has raised this." So yes, the third one is the classic grievance, but other ones are also possibly ones that you need to have a think about. What are we going to do about this, rather than saying, well, it doesn't meet the technical rules, technical definition of what's a grievance, so we can ignore it. So it's I think that the message is, don't be too focused on the specifics and say, well, because it doesn't satisfy these rules, then it's not technically a grievance, so we're not going to deal with it. I mean, I guess the importance of this has lessened to an extent, that the technical bit about being written down. When I was a few years ago, there was something called the statutory dismissal and grievance procedures. Anyone who's been doing HR for a long time will remember those. And the rule said that if you hadn't submitted a written grievance, then you couldn't bring, let's say, a constructive dismissal claim. You had to have submitted a written grievance, and there was lots of arguments and lots of discussion about what amounted to a written complaint. I remember attending, because I was an employment lawyer for 20 odd years. I remember attending a seminar run by some barristers in a law firm on edge of an industrial estate in the evening. All the good biscuits had gone, and we spent an awful long time arguing about what in writing meant. And so I did have to question some of my life choices that evening. But and I think that was one of the reasons that the government abolished that provision, because it became too technical and too legalistic. But so that law's gone now. But there's an ACAS code of practice which says, if an employee hasn't raised a grievance, then if they say go on, bring a constructive dismissal claim, if the employee hasn't raised a grievance, then their award can be reduced by up to 25% if they bring a tribunal claim. So they are still important, because the idea is, and what the employment law wants to see, is that employees exhaust internal processes before they go off to an employment tribunal. Employment tribunals are funded by the taxpayer, and they're trying to reduce the strain on employment tribunals. So what they want to see is that employees are exhausting or going through their internal processes before they take it externally. And so the ACAS code is encouraging employees to submit complaints in writing, so everyone's clear about what it is, and then a process should be followed, and we'll talk about that process shortly. But whilst that third one is definitely meets the definition of a grievance, what I would say is that you should be mindful of the other ones and don't dismiss them just because they don't meet the technical definition. So let's move on to the next slide, please. So this is essentially the grievance process. So I think the main thing I would say about the process is understanding the complaint. And so this can often be done at or should be done at an early stage. And it should, one of the main questions that should be asked every time, if it's not obvious, is what do you want from this? What's the outcome that you're looking for? And so if that can be dealt with at an informal stage, if it's clear that, for instance, the employee just wants some recognition, just wants an acknowledgement that something has happened and something has had a particular effect, then that may be something that can be dealt with in a quite straightforward and quite low-key manner. And so it's really important to ask that question. Now, if it's a bigger matter, then you will probably need to go away and do an investigation. And that's one of the things we do a lot of, because organizations get us involved if there's lots of people involved. It's going to take a lot of time, or if it involves some people who are quite senior in the organization or has potentially quite serious consequences. So it's often the case that if it's a more involved matter, that you will need to do an investigation. And then following that investigation, you would then come back to then have the grievance meeting where a decision gets made. So it's important to remember the investigation shouldn't, in an ideal world, shouldn't make any decisions about the grievance. The investigation should provide the evidence. It's a fact-finding exercise, but ideally that decision goes back to the person who is actually going to make the decision. But another important thing to remember in this process, and it appears throughout the ACAS code, and whenever these ACAS codes are rewritten, it appears more frequently, is mediation. Because with grievances, as I said, the main question you should be asking is, what do you want to achieve here? What does a good outcome look like from your perspective? And so if what you identify from that question is that actually you've just got a breakdown in workplace relations, it may be more sensible to, rather than launching an investigation and going formal and in terms of reference, etc., it may be more sensible to think about, well, if this is just a breakdown in working relations, the classic case would be a communication problem, would this not be better dealt with by mediation? So effectively, what you do then is you would pause the formal grievance process. You're not saying it's gone away, but you would say, would you like to try this mediation process? It's a confidential process. So the option to go through the formal process is still there if it doesn't work, but would you like to try this, which is it's a quicker process, and it may well get you to where you want to get to. So rather than automatically launching into the full-blown investigation, etc., it's worth exploring whether that's a possibility at an early stage. And certainly when I'm doing investigations, I've done, when I'm interviewing the person who's raised the complaint, I will say to them, I'll start asking them questions, and they sometimes will say to me, I don't know why I'm here. I don't know why we're going through this, because all I wanted was a conversation with my manager. Uh, so when I wanted to, I just wanted a conversation. I just wanted my manager to acknowledge that this hadn't been done particularly well, and that that's all I wanted from this. And so it's important to ask that. Sometimes when I ask the question, as when we're doing the investigations, the grievance investigations, sometimes they don't know. And that's interesting. When I say, well, what do you want from this? Why, effectively, why are you doing this? Sometimes they don't know, and they haven't really thought that. Effectively, they're just there because they want to complain. They're unhappy. They want someone to know they're unhappy, and they want to raise this complaint, but they don't actually have an end goal in mind. And sometimes as well, they are doing this because they need to do it. I mentioned on the last, when I was talking on the last slide about the ACAS code and tribunals. And one of the requirements, effectively, of when you're if someone's say thinking, well, I'm going to get a constructive dismissal claim here, I'm going to resign, a bad thing has happened to me, I feel like I've been treated really badly, I'm going to bring a claim. And so if they go and see a lawyer, or they go and seek some legal advice on Google or TikTok or Instagram or whatever, they may well find out, well, actually, you need to go through an internal grievance first before you can do that. So sometimes people go through the grievance process effectively because they think that's what they need to do in order to then be able to bring a tribunal claim. And so in that situation, if you're the employer, it's actually quite a useful opportunity, because there may have been an episode, let's say, that a manager has undermined the employee in a meeting, they've been embarrassed, and there's quite an obvious event. That is probably quite good grounds for a possible constructive dismissal claim. But if you, as the employer, then say, well, hold on, we are taking this very seriously. We want to do a thorough investigation. We take all these allegations very seriously, and we want to look into this, and we want to see what's gone on here and see what we can do to try to resolve this. If you, as the employer, take those steps, then putting it bluntly, that is going to really undermine someone's chances in a constructive dismissal claim. Because if they then go off to tribunal and say, and then my employer did all these steps, and that then I was forced to resign, their chances of succeeding in a constructive dismissal claim have really diminished. And so, there's a number of reasons, workplace wise and tactically, why it's sensible to carry out and be seen to be carrying out a full process if that's what needs to be done, but never forgetting is there a more sort of harmonious, quicker fix to this through possible mediation? So in terms of the process, let's say you are going through an investigation, it's important that you're creating a neutral, safe environment. So it's important that you are letting the employee know that it's important that you're not taking sides. You're there to do the fact finding, to find out what's gone on here, because it's not just from this situation, this not individual situation. You might be uncovering a wider culture. So it's important that you are looking into this, because you often find there's bigger things that you will uncover as you're looking into it. And a safe environment, so they feel that they can tell the employer what's gone on. So you're not going to be getting only a partial version of events, because if you're only looking into a partial version of events, that's going to affect the quality and the usefulness of your decision. So it's important that they feel comfortable to share everything with you that's gone on. Listen actively. So this is either in the investigation or the grievance hearing itself, that you listen actively, that you are encouraging them to talk. So you want the detail. So so when they say, my manager keeps bullying me, he's always undermining me, you're saying, well, tell me about that. give me some examples. When did this happen? Who else was there? When was what was said? Where were you sitting? What other witnesses were there? So it's important that you are getting to the bottom of it. You're not just going away with essentially a set of headlines, because what you'll find in grievance letters, there's often essentially just a series of headlines. There's a series of statements. My manager always does this, that sort of thing. And so it's important that you're saying, well, what do you mean by that? Give me the evidence, give me the examples, give me the most important examples that you can think of. So you're looking into it. And so when you're coming to make your decisions, you're making it based on the specific examples rather than the more generalized headlines, as it were. And it's important that you take detailed notes. I mean, and that's throughout this process, because you never know where this process is going to lead you. If someone, for example, is thinking, well, I'm going to go to a tribunal, if you've got detailed notes, that's going to, again, help you say, well, no, we did take this really seriously. These are the meetings we had, and these are the notes we took at these meetings. Whereas if you've got a scrappy piece of paper with three bullet points from an hour's meeting, that people may well draw the inference that you didn't take it that seriously. So it's important that you take detailed notes. I would say get a note taker with you, so you've got that evidence to show that you are treating it seriously and you are wanting to look into it and do a thorough job on this. That applies not only to an investigation, but it also applies to any grievance meeting. And of course, the final step in this process will be the appeal meeting. So again, it's important that if the employee is unhappy with what the outcome of the grievance, then you should also adopt the same approach at the appeal hearing, any appeal hearing as well. So that's that. So can we move on to the next slide, please? Right, so I'm going to hand over to Claire now.
Thank you, Simon, and hello, everyone. So I'm going to be looking at counter grievances, and you might be asking, what is a counter grievance? So a counter grievance is when an employee raises a grievance in response to a grievance which has already been raised against them. So, for example, colleague A raises a grievance against colleague B, and then as a result of that, colleague B may respond by raising their own grievance against colleague A. And it can focus on the behaviour of the colleague or the circumstances leading up to it. So a counter grievance is not simply a written defence of the original complaint. You would expect it to highlight separate incidents or misconduct, not just provide reasons as to why someone might disagree with the original accusation. So I think it's important to consider whether the grievance is valid in the usual way when you receive it. So I just suggest you explore that a little bit. Counter grievances are surprisingly common, I would say, and there are a few reasons for this. One I see quite a lot is defensiveness. So somebody might feel attacked and might raise a counter grievance as a way to sort of shift the focus from them and protect themselves in some way. It can very commonly become a tit for tat complaint at the end of the day. You raised one against me, so I'm going to raise one against you and see how you like that. So the tit for tat element can be quite common. And it can also be a procedural tactic sometimes. So they might be used to delay or complicate the original process. So you can see from the slide that it's important to deal with any grievance, whether that be a counter grievance or not, promptly, and not allow them to derail the original grievance process, because that actually could lead to unfairness when considering the original grievance itself. So one of the first questions I find it helpful to ask yourself when a counter grievance is raised is whether the counter grievance should be dealt with separately from the original grievance or together with it. And a key question I find helpful to make that decision is around whether the counter grievance relates directly to the original grievance, or do you consider it a separate issue when you're looking at it? So if the grievance is related, I would suggest that you consider addressing both grievances together, because that can help you come to a resolution of everything, and avoid duplication of effort. I'd suggest that's particularly important if the outcome of one investigation could impact on the other investigation. So an example of that, for example, could be an employee, Sarah, might raise a grievance alleging that her line manager is bullying her. Then Tom, her line manager, in turn alleges that Sarah is actually bullying him, and that's not uncommon. Your challenge in running separate and parallel investigations can lead to conflicting findings or delays, even though those matters might be related. So I would suggest you consider combining the investigations in that sort of situation, so you can consider all of the evidence to help you reach a conclusion about the outcome. If when you're reading through that counter grievance and you consider that it's unrelated, then I'd suggest you could treat the counter grievance as a separate matter. And that would mean you're not mixing up two elements, and you can follow each grievance through independently. So if we stick with Sarah and Tom, Sarah, the employee, might raise a grievance alleging that her line manager, Tom, has been bullying her, as we said. But just a bit more detail, if we know that she claims that Tom has made inappropriate comments about her work performance, perhaps maybe in front of colleagues, or has excluded her from key meetings, that sort of thing. And just to make it slightly different, Tom's counter grievance in this situation against Sarah is alleging that she's been spreading false rumours, perhaps, about him to other colleagues. He feels that's damaging his reputation and causing a hostile work environment. So in that scenario, I would suggest it could be argued that the grievances aren't directly related, because Sarah's grievance is focusing on Tom's alleged behaviour towards her in the workplace, and Tom's grievance is about Sarah's alleged conduct towards him outside of the direct manager-employee relationship. So in this situation, I think it could be argued that the two grievances concern different actions, different behaviours, different contexts even, that would make sense for them to be investigated separately to ensure that impartiality and fairness. And if you are going to go down the route of investigating separately, then I'd suggest you use separate investigators for each grievance to avoid bias wherever you can, if you have that capacity. And then they consider the evidence that they've gathered in each investigation, not what they might happen to know effectively from something else. And just to pick up on what Simon said earlier, really, I think whichever approach you go for, I would always suggest that you keep clear records to demonstrate how you came to each decision you made and why, and how each grievance was assessed and handled. As time moves on, as Simon said, it can be easy to forget the reasons why you've made the decision you did. And I'd also suggest that whatever approach you take, it's important to remember to communicate clearly with those involved. Anybody raising a grievance, it can be a big deal. It can be difficult issues, and it's something that can reassure individuals that have raised those grievances if they absolutely understand what's involved and how you're going to manage it. And it can help you manage their expectations as well, and they understand how their grievance will be considered at the outset, can be really helpful. So that communication, early communication, is really key. And just the last point on the slide there, ensuring fairness and consistency. It goes without saying, in a way, that things, you would want things as a reasonable employer to be fair and consistent. But I think it's just taking a very measured approach to what you're reflecting on when that counter grievance comes through, and how you might decide to progress with it, really. So if I could move on to the next slide, please, Caitlin. Thank you. So we're now going to spend a moment considering grievances which are raised during the disciplinary process. And you'll see we've got another polling question so that we can see what you think. What you've got on the slide in front of you are a number of possible responses to an organisation receiving a grievance from somebody who's being taken through the disciplinary process. So I'll give you a few seconds to read them, but there's a wide range there. If the poll can be brought up, please, then you can have the opportunity to make your choices, please, and we'll see what comes out. So thank you. Right, we're getting some different answers coming through, which is always interesting. That's great. No clear favourite at the moment. That's brilliant. I think we're probably getting towards slowing down. So can we have the results, please? That's brilliant. Thank you. So we've got a range of responses there, haven't we? Everything except ignore it. And that is quite positive from my point of view. When you're reading through the examples there, I expect you probably realise that lots of these options have got some validity, to be honest, depending on the circumstances that you've got in front of you. The one that stands out, and you've all clocked it really, is that you shouldn't ignore the grievance. Simon's obviously gone into the background of why that's incredibly important, but obviously that's something you're aware of. So all grievances need to be fully considered and responded to effectively. When a grievance is raised by the person who's a subject of a disciplinary process, I'd suggest that one of the first steps would be assessing whether the grievance is genuine or whether you think it's more of a tactical move aimed at delaying proceedings. When you're thinking about this, I'd encourage you to stay objective, but I do recognise that can be tricky. If you put a lot of time and effort into the disciplinary process itself, there can be a real temptation to make an assumption that something is tactical. But it's really important to just take a step back, reflect on what's in front of you, and make your decision from there. To help you make your decision, you could look at things like timing. Is the grievance being raised at a critical point in the disciplinary process, for example, just before the disciplinary hearing? That might point you in direction of potentially being tactical. But I think the most important thing, really, as with any grievance, I'd suggest, is to review the content of that grievance. So does the grievance, as you've received it, have merit? Or does it appear vague or unrelated to the disciplinary matter, for example? So if the claim lacks substance, or you're comfortable from considering things that it appears to be a delay tactic for reasons that you've established, then you could proceed with the disciplinary process. But as I mentioned before, always document the rationale, I would suggest, for the decisions that you're making. And just to emphasise again, do stay objective and avoid making assumptions about motives without any clear evidence. Any grievance that raised should be taken seriously, regardless of any suspicion you might have about tactical intent. So it's likely that you'll need to consider the grievance, but do reflect on those tactical elements as well. So assuming you consider a grievance is genuine, you've then got to make a decision, I would suggest, about whether to pause the disciplinary proceedings or not. And to be honest, this is normally a balancing act, because pausing the disciplinary proceedings might be necessary to ensure that procedural integrity and fairness, particularly if the grievance relates to the disciplinary process, or involves perhaps allegations against the person conducting the process. But I think it's important to emphasise that there isn't an automatic pause that's required. So you'll need to assess whether the grievance and disciplinary issues might impact on each other, and therefore whether pausing the disciplinary is helpful to ensure that fairness. So when you're thinking about whether to pause the disciplinary process, again, I would suggest it's important to consider the nature of the grievance. So does the grievance that's been raised impact the fairness of the disciplinary process? There will be some complaints about the disciplinary process that are best addressed within the disciplinary procedure, for example, at the hearing or at an appeal meeting, if that happens. For example, if somebody is said that they weren't given enough time to respond to allegations, for example, then that's something that could be addressed at the hearing meeting, and therefore the disciplinary process wouldn't be postponed in that sort of situation. But if you have an employee that perhaps raises a grievance that their line manager, who is also the person hearing the disciplinary, has bullied them, for example, then it could be appropriate to pause the disciplinary process in that situation, appoint a neutral investigator for the grievance, and that can help to ensure that your disciplinary process and disciplinary decisions haven't been made by somebody who may be biased. As I mentioned, for the counter grievances that might be raised, I would also suggest that you look to see whether the grievance actually looks like a defence or whether someone's presenting mitigating factors for the misconduct in the disciplinary. Because if that's the case, then again, it might be reasonable to address the grievances within the disciplinary process itself. Where you do consider the grievance within the disciplinary process, I'd suggest you complete a sort of sense check at the end of the disciplinary process just to see that if there are any aspects of the grievance that haven't yet been resolved. If that is the case, then those aspects can be addressed formally through that separate grievance matter. And through all of this, of course, you can also consider the informal grievance approach, whether that's relevant, whether that's appropriate along the lines that Simon outlined earlier. I also wanted to cover here that it's important to be aware that grievance raised during the disciplinary process shouldn't be a way for an employee to reopen matters that have already been considered and responded to during the disciplinary process. So I'd suggest you just have half an eye on that aspect, because ultimately you can refuse to readdress issues that have already been considered and responded to. So really, whether to pause disciplinary proceedings, I suppose, comes down to the balancing, as I said at the beginning, that balancing fairness to the employee with keeping that disciplinary momentum and avoiding unnecessary delays for the disciplinary process itself. And just to reiterate what I also said for the counter grievances, whichever approach you choose, I'd suggest you ensure that both the grievance and disciplinary processes are handled in line with your organisation's policies and procedures, because that will be key to ensuring you've completed a process that's likely to be considered fair. So make sure you're aware of timescales, make sure you're communicating clearly with the individual. And that clear communication, as I mentioned when we were talking about the counter grievances, if you can explain how each process will be managed and the reasons behind your decisions to pause or continue disciplinary hearings, that will help people understand what's happening and hopefully be persuaded by what you're suggesting. So thank you. I'm going to ask for the next slide, please, Caitlin. Thank you. So the slide we've got in front of us is talking about making balanced decisions when considering grievances. Obviously, Simon's talked about investigations in his section. I can't overemphasize really the importance of investigations in making balanced decisions. They're crucial for ensuring fairness and gathering all the relevant facts, as Simon said, before making decisions. Are going to help you to avoid making any assumptions. The number of times I've gone into a grievance when it's been explained by a client that it looks like it's this, you can uncover so many different things when you actually get down to looking at the detail and challenging the evidence that's in front of you. So a robust investigation process can help reduce any risk of challenges later on. So I'd suggest it's worth taking the time to review everything, explore what's needed at this stage, and that can also help you have fewer surprises later on in the process as well. So that investigation element is really key. Simon also alluded to this as well, but I suggest it's really important to consider the separation of roles. What I mean by that is having a separate investigator and decision maker wherever possible, assuming you've got enough people in your organisation for that to work. This allows the investigator to focus solely on the fact finding and evaluating that evidence and challenging that evidence and coming to a recommendation or a conclusion on the balance of probabilities about what they think is likely to have happened. The decision maker can then review that evidence and recommendation. That means there's a second pair of eyes looking at that information, and they can then concentrate on appropriate outcomes and decisions that need to be made. So this separation can help you to make balanced decision and avoid conflicts of interest. It's also really important for the person hearing the case to remain neutral, whether that be at the hearing or at the appeal, rather than going into any hearing with preconceived ideas. And I'm well aware, of course, in different organisations that there's often a history, there's often a story behind these things that happen. However, that needs to be put aside so that you're just considering the evidence that's in front of you and remaining neutral. Might be particularly difficult for a manager who might be frustrated by previous conduct or something of the individual, but concentrating on that evidence can really help to ensure the neutrality. And keeping a language in meetings and in writing is neutral is also important, I'd suggest, because that can help, that can sort of move away from any assumptions that a decision has already been made before the hearing is even finished. So if you can keep that language neutral, that will really help you in the long run, I would suggest. And to emphasise what Simon and I have already said, really, I would suggest that balanced decision has got to be focused on the evidence that's been gathered during the investigation to avoid those assumptions that might be made. Ultimately, basing your decisions on evidence and the balance of probability can help you to ensure that whatever decision you come to, it's defensible and it's credible to those involved. Simon's mentioned, of course, that there's going to be there's an outcome letter that comes from a grievance process. So communicating outcomes clearly and empathetically, I would suggest, is important, because this is your opportunity to explain your outcome decision and hopefully convince the person raising the grievance that your consideration has been fair and reasonable. How much detail you include in writing will depend on the circumstances of the grievance. It could just be headlines that's most appropriate, or it could be that you want to put a bit more detail in there to help the individual receiving the letter understand what's being said. You can also, of course, have a meeting to share the outcome and then hand over the letter as part of that meeting, allowing you to have more of a discussion around matters that may not be put in writing, that you may not therefore be held to account for later. So using plain language when you're writing to an individual to set out the key points can be really important. Use language they'll understand rather than any jargon. If you can focus on the facts rather than opinion, that will be really helpful. Perhaps you might want to summarise evidence and explain how it supports the decision, but there will be times when you do just want to keep to the headline information. But as I mentioned before, avoiding emotional or subjective language is really important, so that you're evidencing a reasonable decision effectively. And I'd say it's also important to be specific. So if you can clearly outline the decision around each aspect of the grievance, and any next steps or actions required as a result of that outcome, then you'll make sure that you've addressed all of the issues that the individual has raised, hopefully helping people to move forward. And part of that really is having that respectful and professional tone throughout, even if the decision is unfavourable to the recipient, because it can really help with how that's received. So I just wanted to touch on, before I finish, the value of sort of transparency, I suppose, in maintaining trust and credibility when you're looking at grievances. When dealing with grievances myself, I've always found it important to remember the people involved in the grievance process are going to still work for you after the process is finished. So if you're transparent wherever you possibly can be, that can help to maintain the trust and credibility with the people involved, and can help to reduce perceptions of unfairness or bias should they be raised. And more generally, as Simon also mentioned, it's not just the individual raising the grievance, of course. A transparent approach can reassure other staff that issues are handled objectively by your organisation and fairly. And that's really important to give other people confidence to raise matters when it's necessary for them to do so. And my final point before I hand back to Simon is just to bring it back to policies and procedures. So applying your policies and procedures consistently reinforces that trust and confidence and transparency, both in the process and how the organisation responds to the complaints that are raised. So always go first to your policy and procedure, check the steps that policy refers to, check the timescales that it refers to, make sure you adhere to those. If it's not possible to adhere to those, make sure you're talking to the individuals involved and getting their agreement to make any changes to what's actually set out in the procedure, and keep those records around when you've done that, those detailed records that Simon mentioned, to make sure you've got that evidence in front of you. So thank you very much. I'm going to hand back to Simon now.
Thanks, Claire. Caitlin, can we just move on to the next slide, please? So this is really a summary of where we've got to. I think it's just picking up on Claire's point. When I was still practicing, I would often get calls from various HR managers who would frequent flyer clients, and they would say it's John. He's done it again. So it would be about a particular employee, and so like when they would be interviewing John, they would sometimes start with words to the effect of, "What is it this time, John?" And that, I think, is that mindset is not going to be particularly helpful. And I should say, you have to, whenever you get one of these, you have to imagine, I know it's difficult, but you have to imagine they're your best employee. They're your best, most productive employee, and you treat them like that. So you don't get into this mindset of labeling of they are troublemakers. So yes, you've got to stay neutral and try to look at each situation on its own merits. Do that early process. Do that early process of how do you want this to be resolved? What does a good outcome look like from your perspective, rather than launching into the full-blown process? Yes, you've got your written procedures, there's the ACAS code, etc. But I think the question is this something that can be resolved quite soon, quite effectively? Rather than going through the full process. What I would say, again, my other job at Narrowkey is doing mediations. What I would say is that it's worth thinking about going through a proper mediation process, because when you've got two people who are at loggerheads and are quite angry with each other, trying to just put them together in a room and just effectively some well-intentioned manager sort of trying to knock their heads together and say, come on, sort this out. That may well make things worse, because the thing with the mediation process is you spend time with each of them individually and try to get them to think more positively about what a good outcome looks like from their perspective. And so the hard work is done in the morning. So I would say, if you are thinking of going through mediation, then think about getting a trained mediator in, because it is quite different than just getting them two together and say, right, sort this out, you two. This can't go on. And just some other tips there about documenting everything. You can't. It's even down to your thought processes, because those documents there, that's contemporaneous evidence. Again, thinking through, if this ever ends up in an employment tribunal, if you can write down how you've arrived at your decisions, what the process was, what was important to you, what the important bits of what you've heard were, that is going to be invaluable. You keep hold of that, because that, if you find yourself in an employment tribunal in 2 years' time, given the the waiting list for employment tribunal cases, it can be an awful long time. If you've got a document that you prepared on the day, you'll just refer back to that and say, look, I took this seriously. Here's my notes. Here are the processes that I've thought through. You'll have forgotten about most of that, but if you've written it down, that is invaluable. And don't ignore grievances. Don't just, you may have had enough of someone, as it were. You may think that they are just a troublemaker and think, oh, it's just another one. But you mustn't just ignore them, even if they are someone who's got on your nerves for a while. Don't rush processes. Again, it's important you're seen to be taking it seriously. If it can't be resolved informally, again, it's not saying don't always jump to the process, but see if it can be dealt with more informally through mediation. But if it does need to be dealt with properly and proper process, then don't rush it, and don't make assumptions. Don't work on the basis of this person is just out to make trouble, so we're going to do it on that basis. Because what you may find when you look into it is there are important things that they're raising, and it may be that you will uncover issues, and we often see this, you often uncover issues about a wider culture. So there are things that you will learn about the way that an entire department is running that you wouldn't know if you'd done a quick investigation into a grievance. So that's all we've got to say on that summary. So let's move on to the next slide, please, Kaylin, which should be the questions. Right. So are there any questions you've got for us? And if you do have any questions, if you want to just put them in the Q&A box, and we will all apply our minds to them. I mean, does anyone have any live grievances that they're dealing with at the moment? Just ask you a question. And if so, how's it going? Right.
I wonder, Simon,
Yeah.
whether we could chat about the issue that sometimes comes up about who people might want to bring as their companion. We often get, don't we, asked about people wanting to bring somebody along to a grievance or an investigation meeting
Yes.
who isn't their union rep, isn't
Yeah.
somebody who works there, is perhaps their partner or their friend. And how might you deal with that?
Well, I mean, particularly in grievances where someone is feeling quite vulnerable and is really struggling with whatever they are dealing with, I would, it's a sort of last resort because you would usually just stick to the workplace, work colleague or union rep at a grievance meeting. But if that's the way that you're going to hear the evidence and hear what they've got to say, then I would suggest you you do that. You let them be a company, because the important thing is you hear what they've got to say, and I mentioned earlier, you hear everything they've got to say. You don't just hear a sort of sanitized version or an edited version. You want to hear everything they've got to say. So Emma has got her hand up. Her hand up. Is that just in response to my?
I think we've actually got a question. So the question
Okay.
is, if a wider culture issue is identified, do you keep it separate to the grievance process?
I think that's probably dependent on the on the matters that are being raised, to be perfectly honest. If they are connected to the grievance process, you will need to pause and think about what actually it is that's being raised. It will depend on how your procedure suggests you you deal with any collective grievances, or if other people are coming forward. So I don't know, Simon, you might say differently, but I don't think it's an easy answer, to be honest, because you need to evaluate what you've got in front of you.
I think sometimes we would perhaps do it as two phases, wouldn't we? It might be that you deal with the grievance that in the way that it affects the individual, but that sometimes recommendations may be, or observations may be, that there might be some wider organisational issues that have been unearthed as part of this. And then a recommendation perhaps that the organisation might want to look at that as a separate sort of stage 2.
Yeah, I mean, certainly when I've the typical one I'm thinking about in that situation is where you've got someone who, there has been complaints of, let's say, jokes, there's sort of quite, personal jokes get made, and someone's been offended by those jokes. And when you do the investigation, you find out actually there is a culture. The whole team do this, and it's led by the manager. And this is not an isolated example. So that is something that you would probably say, well, look, there is an issue here, and that seems to be, there's evidence to say that is happening, but actually there's a wider issue here. And then probably, usually as a recommendation, you would recommend that everyone gets put through banter or harassment training, and reminded of the policies, etc. So that often happens where you're looking into a particular individual's experiences, but then you find actually that there's a broader issue to be tackled.
Thank you. We've got one other question, which is, would you accept a grievance if the employee has not long left the organisation?
I mean, I guess with my old employment lawyer hat on, I would say yes, because that is likely to be, part of a if they're raising a grievance, often, like, let's say in their resignation letter, that's the parting shot, and they may well be thinking of bringing a tribunal claim. And so I think being seen to, particularly if they're making some very serious allegations, I would be seen to be looking into that, because that is, you may want to do it in writing, not necessarily with a meeting, not necessarily going through the full process. That in the old days they called it the modified procedure, so you probably would adopt something along those lines. But I think, particularly if they're making some serious allegations, but let's say harassment, you would say, right, we are taking this allegation seriously. We want to investigate this now.
And sometimes policies will specifically refer, won't they, to what happens if a grievance is raised after employment. And it may be, as you say, that you'd use a truncated process rather than the full process.
And there's
I
one
just check,
one
has
about,
it got anything
is
else?
it acceptable to attempt mediation whilst an employee is signed off by the doctor? So I think the answer is, well, it comes back to one of there's 5 rules about mediation. Well, the way we do it, and one of the most important rules is voluntary. So you can't ever impose mediation on anyone. You can suggest it to them, and you can say, like, I know you're off with stress, but would you be prepared to do that? So that's the case in any mediation. You can't force people to mediate. You can recommend it. So I think that it's something that you could suggest, but you did not necessarily. You can't force anyone to do mediation.
And one final question. I'm conscious we've just hit 10 o'clock, but if we can look at this one, is does an employee have to wait for the grievance processes to be completed before they go to ACAS and issuing an ET claim?
Um, I don't think they don't have to, but if they jump the gun, then that may have an impact. If they win their claim, then that may impact on their potential award, because they can have a reduction of up to 25%. But it may be tactically as well, because you've got 3 months to get in touch with ACAS from when your employment's ended. And if the employer is taking a long time, sometimes deliberately a long time, to deal with to come to an outcome, then sometimes the employee needs to go through the ACAS and the tribunal claim just so they don't run out of time. So again, that is something that a tribunal would take into account, that that they don't want to miss the boat. But certainly you need to be seen to be taking processes seriously and going through them, because it can increase the award effectively if as an employer you've ignored a grievance or not really done much with it. So the onus, it works both ways.
Thank you very much. I think that's it for the questions. Um, Thank you so much for joining us, everybody, today. Please feel free to get in contact with any of us if you have any queries. We will send out the recording and the slides, and we've just got a feedback poll that's popped up, which we'd be very grateful if you would complete, and hopefully we'll see you at the next session. Thank you so much.